Now, this document is the previous 20 years analysis of each topic. So every topic that we are dealing today will be analyzed from UPSC Law Optional perspective. That is previously from this particular topic, how many questions has appeared. So our strategy will go in line with UPSC's demand. So that is my point. Okay, look at this table. So this is how each year we used to segregate the question and identify from which topic, the concerned topic, under which areas questions have been asked vigorously. What is the idea of UPSC? That we will decode first. Okay, after decoding the same, after identifying the areas, then we will frame our lectures. So what will be your strategy? You will be following the lectures simply. So in lectures, we will be concentrating very important areas. This is important for both the students who are new to law and also who are well versed in law, because you see the standard book for constitution is this one. Everybody cannot forget this who have done law. This is MPJ. This is the most standard book from where UPSC questions sometimes occurs verbatim. Okay, so this is the book you're going to follow. See how bulky is that. Humanly reading the entire book and retaining will be very hard. So that's why we have decoded the standard books in a different form, which is actually required for UPSC. That's what we are going to do in this lecture. If you see the topic of constitution, constitutionalism, the first topic under constitutional law, this topic have been asked 17 times in the past 20 years. Sometimes even 2 questions have been asked from this topic. You see how important is this? So if you're reading, listening to this lecture, 15 marks or like at least 10 marks is confirmed for you, okay, in the coming weeks. So first most important topic is federalism. When we're talking about federalism, each and everything about federalism is not important. What is competitive federalism? What is cooperative federalism? What is the difference between these two? What is the novel attributes, features of our Indian federalism? Whether our Indian federalism is unitary or federal, that's what is important. Okay. Next, we should read what is secularism. I think it has been asked in your recent mains, okay, and it has been asked totally thrice. Secularism, very easy concept, very easy to score more. Okay. Next, what is rule of law? That's also a very important topic. And negative and positive aspects of constitutionalism. Earlier, we are talking about constitution, not constitutionalism. Constitutionalism is a different topic that is important too. And next, what is a federal government? What is a federal constitution? That we have to distinguish. Okay, this is our framework. That's how we are going to proceed. Okay, so now let's start with the topics quickly. Now, we are coming to the most important first concept, which UPSC always asks a question, which is constitution versus constitutionalism. See, constitution is nothing but a document. This just a document is called as constitution. I already told you. But the control over the government is called as constitutionalism. So the keyword for defining constitutionalism is limited government. Constitutionalism means limited government. If you're not mentioning this keyword in your answer, you will lose marks. Okay. So how limited government is constitutionalism. What is the meaning of this limited government? Very simple. You have checks on the government. So if they are transgressing each other, I told you, right? There are 3 organs. They are not allowed to transgress on each other, and altogether they cannot transgress on the individual citizens. So this check and balance which is kept is called as limited government. Okay. For time being, you understand this. When you're talking about constitutionalism, there are very important statements that we must note. Why we are noting statements? Because UPSC is very keen about statement-based question. From where these statements come? They come from the standard book. So this is a snippet from MPJ. Okay, so I have marked the important statements here. Please go through. First statement is, a country may have constitution, but not necessarily constitutionalism. You understand the meaning here, right? A country can have the document constitution, but this document need not spell out that the organs of the state are controlled. They can have unfettered powers. Okay, so a country can have the document constitution, but for the mere being existence of that document, it doesn't mean they have the concept of constitutionalism. They can either control their government, or they can leave it unfettered. One such example is dictatorship. What happens? A dictatorship can definitely have a constitution, but they need not be having a constitutionalism. There is no see, the constitution reads like this. It will say like, whatever the ruler says, that is the law. Whatever the ruler does, it is justice. If it states like this, whether there is constitutionalism, no, there is no constitutionalism. That's what the statement based. Okay, based on the statement, you can get a UPSC question. That's why I'm pointing out. This is one statement. Next statement, constitutionalism is the antithesis of arbitrariness. I told you, right? See, controlling power, limiting the power of the government is called as constitutionalism. When you're limiting the power, there is no absolute power, then there can be no arbitrariness. So which means the constitutionalism is just opposite to arbitrariness. That's what this statement means. It was given by this particular thinker in his book. Okay, so if you are given a statement based question, you must be lucky. So if provided you are able to identify the meaning and who gave the statement and what is the context of the statement, that's why I'm giving the author nod. Okay, so next we are going to the next statement, which is antithesis of constitutionalism is despotism. Despotism is nothing but being like a monarch. Okay, so all these statements more or less mean the same thing, but if it is given, you have to give your answer accordingly. Now let's see how you can understand the concept, how it is anti-arbitrary, how it is against despotism. We will see everything. Okay, one by one. The concept we told, it is limited government. It means the executive, legislature, and all these power are limited. It is not an uncontrolled power. It is not an arbitrary power. So first you have to give the key term and then give the meaning, and this is what the meaning. Okay. Next, what you will do, whether this constitutionalism, we know the concept of constitutionalism, what it is, but whether it is in existence in India, that will be your next concern. Yes, it is in existence in India. We see a lot of limitations in our organs. What are the limitations? We'll see now. First, very, very important modern thinking of constitutionalism, we got it from the Germany. That is the basic structure doctrine. This doctrine was given in which case? Shankari Prasad? No, see, like, no, it's not Shankari Prasad, I know. I'm just asking you. Shankari Prasad?
No, well,
Shankari Prasad? Who told you? Yeah. So why I asked this question is that I have got three to four aspirants telling that this basic structure doctrine was from Shankari Prasad case. If you are a law student, please be very careful. You will get confused because you're reading a lot. Okay. Shankari Prasad was the inception of the war between the legislature and the judiciary. Okay. That we will be discussing on Article 13, whether the amendment is law or not. Okay. That is different. So where this doctrine is given was in Keshavananda Bharati versus Union of India. So we will just touch upon this doctrine for the sake of knowing what is a limited government. Okay. In the Keshavananda Bharati, there was a huge tussle whether the parliament has unfettered powers to change the entire constitution, to change wherever area it likes, whether it can do so. That was a huge question. But the court told it was we the people who decided it to have certain basic things, right? We all agree to have certain morality, certain things. We conceived ourselves to obey these things. Then only we promised and we created our state based upon these things. So such things will be called as the basic structure of our constitution, and it shall never be touched upon by the parliament. So it cannot change those basic structure. You understand how judiciary has placed a limitation over the parliament? So this limitation is an aspect of constitutionalism. Okay, what is the basic structure? We will discuss later when we are discussing Article 13. One such basic structure is our preamble. Whatever given in the preamble is a basic structure. Fundamental right is a basic structure. This has been identified in different cases. So the point is the identification, creation, or adopting the basic structure doctrine is a feature of constitutionalism. Okay, limiting the government. Okay, that one we have to know. From where we took this point? From Germany. Okay, now we will go. So why this doctrine came into picture is that the organs were created by the constitution. Now this constitution cannot be itself changed in such a way that by these organs that its identity is totally changed. So that is the rationale, okay, for this doctrine. Now, we were talking about constitutionalism is the antithesis of arbitrariness and despotism. For this, you have to give 2 points. First point, there is a saying that power corrupts and absolute power corrupts absolutely. Okay, so when this happens, if a government, a state is given absolute power, then it ends in total arbitrariness and corruption. To stop this despotism, we have created the mechanism constitutionalism. First point. Next, if you allow the king, like see, if you don't control the government, it becomes a monarchy, right? Then it will start jeopardizing the freedom of the people. So you must keep some limitation on the activities of the government. So in order to safeguard the freedom of the people, we have listed out their freedom as fundamental rights, which cannot be transgressed by the state. So listing of the fundamental right per se is an act of constitutionalism. Okay. Next, to preserve personal dignity, see, once your freedom is tampered, your personal dignity is also tampered. Okay. To save all this, we have created the concept of constitutionalism. That's why it is against arbitrary, antithesis of arbitrariness, and it is against despotism. Okay. So when any question comes on this point, you have to give all these things. It will be a little bit of philosophical things, but we have to give it, right? Okay. So now we are going to identify the areas in our constitution which list out, which has the features of limited governance. That is our constitutionalism. Okay. First one, it lists out the fundamental rights and guarantees remedies if this fundamental right is violated. Fundamental rights are listed under Part 3 of our constitution. If this is violated, you can file a writ under Article 32, which is again your fundamental right, and also under 226 to the High Court. If this is High Court, what this will be? This will be Supreme Court. So this is the first feature. Next feature, they create a judiciary. It is not a judiciary which is under anybody's control. It is an independent, impartial judiciary. Why? Earlier, you see, executives were doing the work of judiciary. Later, this judiciary was separated from this executive. We have a separate article for that too. So creating an independent judiciary will be a watchdog on all these organs by using its power. Which power it is? Power of judicial review, and it will watch closely whether any organ is abrogating all the powers. If it is done so, it will control them by its judgment. Okay. Next, you have a legislative check on the executive. So you have different articles talking about that too. Legislature will indeed have a check on this executives. There are reports on the governance and the schemes, everything which should be placed before these legislatures for even in a quarter's time or in 1 year, something like that. So even legislature is having a check. So this is an idea of checks and balances. There are 3 different people, but these 3 different people will be checking each other. That's what is checks and balances. Okay. Next, you have the doctrine of judiciary. I told you, right? Judiciary will be exercising this. Then you have most important concept, which is rule of law.